आधे बाउल दही में 4 चम्मच MDH चटनी पुदीना मसाला डाला, स्टर करो, पुदीना चटनी तैयार। MDH चटनी पुदीना मसाला।
Now, viewers, I'd like to go to another subject, which is the subject of my second debate today. Suddenly, one of the biggest inheritance battles, most high profile, glamorous, as some people say, being fought in India, has seen a huge twist tonight. There are now some documents circulating on social media which allegedly put the entire claim of Priya Sachdev, wife of Sunjay Kapur, under a cloud. Now, this battle has been on since the untimely death of Sunjay Kapur. The whole battle has revolved around the will that decides who gets how much part of his 30,000 crore apparently empire. These documents now circulating and big claims being made are that Priya Sachdev was not present when even the will was signed. I'd like to say that we can't vouch for the authenticity of these documents. But the documents which are being reported suggest that she was in Delhi. She was not there where the will was signed. I don't know what the truth in this is, but the implications are big if this were to be true. Let's take a look at the latest twist in the story and then we'll debate.
A high-stakes 30,000 crore inheritance battle and a shocking new twist. On your screens, the will that was signed on 21st of March 2025 at the Oris Investment Private Limited office in Gurugram. Priya Sachdev claims she was present as an eyewitness when the will that leaves late industrialist Sunjay Kapur's entire personal estate to her was signed. But there's the unexpected turn. Documents circulated online indicate that on 21st of March, Priya Sachdev was allegedly in Delhi and not Gurugram. For the whole day, there was no record of her mobile tower pinging at the location where she was supposed to be the eyewitness. A will already under scrutiny. The fresh evidence now directly challenges Priya Sachdev's sworn statement in the court. Claim versus claim. A family at the center of a wealth controversy. Did Priya Sachdev lie in court?
Now, first of all, I can't take responsibility for the authenticity of these alleged call detail records which are out there in the public domain, and neither can anyone. But this is a big fight. Eventually, call detail records can only be supported or confirmed by the government or the authorities. But what do these call detail records apparently show? The claims are being made on social media that they contradict the sworn affidavit of Priya Sachdev filed before the Delhi High Court. I don't know the truth in this. However, I'd like to get opinion from two sides. I have those who are for Karishma Kapoor in this case, or for people who are against Priya Sachdeva, and there are people who are for Priya Sachdeva. Against Priya Sachdeva, I'm told, Prem Rajani, he is a legal expert on corporate law and inheritance disputes. He's founding partner of Rajani Associates. We also have Ashok Paranjape, very senior advocate and lawyer, managing partner at MDP Associates. We have the executive editor legal of Republic Media Network, Ridhamanand Bhardwaj. And we'll be joined by very, very senior family law lawyer, advocate, senior advocate Mrinalini Deshmukh, who will join us in a bit. Okay. Rhythm, first of all, what do we have here? Can you unmute yourself, Rhythm? Hello? I can't hear you. I've just been told the problem in our audio. We're trying to fix it. Okay, no problem. Mr. Paranjape, what can I start with you? What do you think? What do you make of this?
Yes, so I think I would like to begin with the fact that the hearing has been completed by the High Court judge, the learned judge, and the case has been reserved for orders. So essentially what happens in such cases is that no further evidence, if it is, comes to the hands of the plaintiff, can be led. But of course, in this case, she can make a application to the High Court and say that this is the evidence which is very germane to the case. And that is why it should be admitted in evidence, or rather whatever evidence she has in this respect, that she can produce before the court. But what I believe from the court records or orders which I have seen is that the court has said that now no further pleadings can be filed. But of course, the judge has the complete discretion in this case. And let us, I think, be mindful of the fact that this matter is really sub judice, which means, basically, no adverse, comments or etc. can be really made. So I think we should be mindful of that fact also.
Ongoing public debate on this. Mrinalini, what are your thoughts on this? Where do you think this case is headed? And what do you make of these documents now being circulated about where Priya Sachdev allegedly was when the will was signed?
See, I'm talking from a legal point of view. A will can be signed by anybody at any point of time, and it could be notarized also if at all there is a thing or registration can be done at any point of time. That is what we are talking about, the will. Now, wherever the will is made by the person who is a deceased, correct? So the will is presented by the person who is the executor or who probably could be a beneficiary to get those things done. So where was Priya Sachdev? Does it really matter? What the courts have to test, in my understanding, and I'm subject to correction by my learned panelists there if there is other factual error, is that the court has to consider whether the will is a valid will, whether there has been any fraud or any kind of coercion or anything on this. And thirdly, and more importantly, does the will look very lopsided or it looks very balanced? Reason that the courts only have to go by what is written in the will. And today, as you know, with the amendment that has taken place, the probating of the will also now has been done away in cities like Chennai and Kolkata and in Mumbai also, which otherwise we needed to do in cases of immobile properties. So even that has been done away. So I think the role of the court here, whatever may be the drama around the whole thing, is only to see whether it's a valid will or it is not a valid will, and that will have to be tested on the touchstone of the evidence and the witnesses and the examinations which are there. Now, these documents which have come up can only give a little bit of color and things like that. The real meat of the matter is what is in the will and how the courts are going to interpret it.
But if it is said allegedly that she says she was in X, but she was actually, as per CDRs, in Y, then what happens in a case like that?
The will is made by the deceased. The will is made by the deceased, and wherever his wife, his child, his daughter, or whoever may be, has nothing to do with it. Most of the people make their will in absolute secrecy. They may say, okay, I'm going to a particular place, and they may go to some other place and make their will. Whatever may be the case.
Okay, one minute. There's another angle in this. Where is this whole issue rhythm of who is where? How is it relevant? To the point which Meenakshi raises now, that the will is made by the deceased. Where does Priya come in?
Exactly.
Mrinalini, very good evening. I think all of you making decent points about where a will should be. But today, the twist that Arnab is talking about and what we are debating is a little different. The will has been argued. The case is already now in the Delhi High Court. But what we are looking at on social media is new call data records that are suggesting that she has possibly given the wrong facts in the Delhi High Court on the sworn affidavit. As defendant number one in the case, she's written on a sworn affidavit, and that's the graphics that we were playing out, that as defendant number one, she was present. On the left side, we are showing that she says that on 21st of March, 2025, this will was signed. It's a paragraph from that affidavit. 21st of March 2025, when the deceased Sunjay Kapur signed the will, she says she was present. Now the call data records on the right side of the screen show, in fact, that on the 21st of March, she was not present in fact, Gurgaon. The entire day she had been in Rajokri, apparently where she stays. So this raises a different question, not only about the authenticity of the will, which allegedly is forged, is what has been stated by the lawyers of the other side, which is, of course, for the Delhi High Court to decide, Arnab rightly pointed out. But the larger question here, has she lied on oath? Because then this becomes a case.
But it's a question. I mean, how is the point being made here? Rhythm. It's a question. In social media, you can say a lot of things, but
how does that perjury completely reshape the will? I'm talking as completely as a lawyer. How does one statement completely reshape it? Of where she was?
But
No, but
because
if it's a new
I don't know
evidence,
whether it does.
the point is, Mrinalini. See, if now, if a person has given the wrong facts on an affidavit,
absolutely.
right? And she says, I'm just saying, if she has said that I was present when the will was signed, she need not have said that. It is not germane to her claim. I agree with you. It is not necessary for the beneficiary of a will. A person can sign a will in Delhi and the beneficiary may be in Antarctica. It makes no difference. However, the argument being made is that has she said that she was there when the will was signed? Now that she has said that I was there when the will was signed, is that not giving a wrong information on an affidavit? And if it is therefore wrong information on an affidavit, Prem Rajani, does that have an implication on the case itself?
Hi. So I think on this point, I'll slightly digress to this point that what statement was made to this element right or wrong. I'll answer that a little later also. The subject is, because I like Ashok transparently mentions a sub judice matter, so we should not speak more on the exact argument the senior counsels in the court.
Yeah.
But just coming back to your point, I'll just take a minute digression. When we have clients of such high profile clients, naturally the process where they make a will, they make a trust, they have appoint law firms, accounting firms, or trust fiduciary companies. There's a long drawn process. The quality of witnesses all matters a lot. Whether it was given to X or to Y, that's something for the testator or the deceased person to decide how he wants to distribute the property. But in this particular transaction, I see none of them happening of that nature. I'm not sure whether any law firm was really involved in preparing this particular will, whether it was registered with the sub-register, which is a common practice when the stakes are very high. And we have quality witness. You just don't pick any two random witness. Nothing by law. You can pick anyone for witnesses. But Ashok will also agree that we always pick up a law firm, accounting firm, somebody more responsible to give an affidavit of the validity
So
and the
normally
presence
one
of the
doctor, one
testator.
lawyer is what we normally do.
That's the normal practice.
Advise
And
the
and
But that is
so they
only
were not
to-
really discussing on this matter. Back on the matter when Rani mentioned that one of the aspects of the particular affidavit being incorrect, perhaps I agree with her that it can be overlooked for the larger picture. But this is just one of the very smaller factor point of the location being present in Delhi or Gurgaon. But I see far more than just one statement in the particular affidavit, which should be looked upon or discounted. But I think one has to look at a larger picture of how one would make a will of this particular stake involved. I'll take a break. Somebody else may want to add something.
No, I would just would like to
Is
add
everything?
Prem,
Yes. Yeah, go ahead, sir.
In this
No.
aspect, is that the will need not be registered. I mean, it's not mandatory in law that the will has to be registered. All that is required is there should be two witnesses who would have seen the testator, that is the making of the will, and that the testator has signed in front of them. So that is what is.
But again,
important.
I ask you this.
And,
Sir. I am confused about one thing, sir. If I may come in for a moment, I'm confused about one thing.
Yes.
Why is she saying that the will was signed in her name? Legally speaking,
Yeah, absolutely.
Ashokji, why is she saying she was present?
Correct. Yeah. So that might
Why
be a
has she
factor
made that part of her affidavit?
That might
Why
be a
has she
factor which will
mentioned
give
that
the
at
plaintiff the
all?
right- Yeah.
Has she
Correct.
been misled? Has Priya Sachdev been misled by someone into making that claim in an affidavit that I was present? How is that material to her claim? Why has she done that? That I was present. You are the beneficiary. Whether you are present, not present is irrelevant. The witnesses have to be present. If it is proved that the witnesses are not, why does she have to say I was present?
Now, that is something which we cannot really answer. I mean, her lawyers need to.
Tell you what, in the what do I say, the excitement or things of bringing out the so-called authenticity, sometimes I have seen in my profession that people do go overboard and overemphasize and over sort of state certain things which are not necessary to be stated. That is where a person like a lawyer, like the caliber of the lawyer that we have here on this panel right now, are the ones to
Said,
guide.
Meenakshi, leave the document circulating in social media aside. Let us, Mrinalini, let me disregard that. What is in social media? Let me disregard the call detail records. Let me say that is all a lie. Let me say that is rubbish. That is in social media. It holds no legal claim. Let me take that position that I don't know where she was, which tower, which location. I don't know whether the documents are fake or not. It's circulating. Fine. Forget all of that. Okay. I am only on another point tonight. I forget all this. The CDR controversy, telling a completely different story. Let us assume this is all malicious. We are discussing is because it's become an issue. It's trending. It's on social media. Obviously, a high profile case. It will gather attention. My question is, she has said in her will that the signature of the late Mr. Sunjay Kapur along with the signatures of the witnesses are duly affixed on the will. Defendant number 1 was also present.
Yeah.
She has said defendant, which means she was an eyewitness to the signing of the will in her interest in the presence of, okay, he loves his wife. He's getting the will signed by eyewitnesses telling his wife that I am giving you everything. This is the claim. Now, first of all, why is she saying that? That, my lord, I was there when the will was signed in which I am a beneficiary. I'm sorry, that is not, I mean, I don't know, has somebody misled her, Mrinalini? Who does this?
Not but to show the authenticity that I am vouching
the authenticity when you're the defendant. I'm sorry. Mrinalini, to show the, no, 1 minute. Forget this. Forget the CDR. You are showing the authenticity of the will by saying I, who is benefiting from the will, was there when the document was signed in my interest by my late husband. Now, you have said this, you've added that line. Now you've opened yourself up to questioning. Where were you actually? Were you at a party? Were you in a, what does your call detail record show? Where were you? This issue would not have been an issue had she not made the claim that I was there when it was signed. Has this been a legal mistake by her?
But Ashok would agree that some of them, they overstate the things which are not required. And that is what...
Did she overstate that? No, point being, Mrinalini, you see, it's an Abel Mujhe Maar situation. You have gone and overstated that I, defendant number 1, categorically say I was present when the will was signed by my late husband, putting it in my name in front of these so-and-so lawyers. Why are you saying that? Has somebody misled her,
only the lawyers can answer that. It will, I mean, for us to state something on this topic. And Arnab, there is
stating anything. I'm just saying that now that this issue has come up, it's just a commonsensical question.
Yeah. No, just one major point. The CDR records actually are not accessible to third parties or members of the public. Now it will be a point of how will be the plaintiff able to prove as to how the CDR records were obtained by whoever has obtained them and put on the the social platforms. So it will be a
social media. A lot of things circulate on social media. It gets picked up. Maybe it has no relevance.
But that authenticity will have to be proved ultimately.
Authenticity cannot be proven.
So if we assume that the plaintiff would file an application for admission of the CDR records as part of evidence, then they will have to actually prove that it is authentic or get an order directing the authorities, the telecom TRAI authorities to produce those records. That is my submission. Take on this.
We do not know how they have come because this is still not tested. And Ashok, as you rightly said, that this is still matters are sub judice. It's for the courts to decide. So it may not be appropriate for all of us on this as the lawyers to really, sort of get into it to any kind of a situation. But I think what Arnab is trying to say is that what could be the motive? That is a very general question. That what could be a motive is what he's trying to ask us by stating this or overstating some of the things. I think
the point I'm making, Mrinalini, is if you look at it, I am not a lawyer, I don't know, but it appears to me, you people are the big lawyers here. It appears to me that Priya Sachdev has overstated her case to start with.
Yes.
Huh?
Yes.
Has someone misled her to doing that?
Yes, misled her. Yes.
Perhaps over
Lawyer, somebody's putting this up for her.
Overstating is not advised by lawyers. Lawyers always say that it is better to be very factual and not overstate. Better to understate and then make an amendment if required.
Overstate, if you overstate, then you are subject to questioning.
Yes.
Somebody is going to find holes in your argument.
Yes, of course.
I don't know, I think so.
But there is one more thing that the court is also going to be looking at, like the lawyers also said, Arnab, there has to be an application in the court for the call data records to be made public. It's possible, even if not public, it has to be placed before them so that the courts can, in their wisdom, decide what needs to be done. Because the larger question now, Mrinali and Ashok, will become, was the document at all executed? If possibly there is an allegation now that the eyewitnesses could be lying. That's the bigger question that this could lead to, which the courts have to, in their wisdom now, examine.
Yeah, I guess Prem, last word to you, Prem.
In fact, in my view, one statement may require them to look at all the statements with a microscope.
I tell you one thing. My feeling is that it's a bit of a catch-22, Mrinalini's lawyers put this in that she was present.
Yeah.
Now they'd be regretting, why did we say she was physically present? It would have made no difference whether she was in Honolulu or present there. Right, Mrinalini?
Innocuous statement.
If Mrinalini had been the lawyer, she would not have allowed it, I think. Okay.
Always ask, it's better to understate than overstate.
Well, don't overstate, you have nothing to defend. Understate is the lesson lawyers are taught. Somebody's made a mistake here. I thank you very much. This is quite interesting, is all I'll say. I'll just be understated in saying that rather than overstate myself in that this is all very interesting. Now at 9 p.m. tonight, I'll tell you why I support the government when it says that this 10-minute delivery should stop. This 10-minute delivery. I don't know who does it. Blinkit, Swiggy, Zepto. Why are people in such a hurry? Who makes money by forcing gig workers to deliver that parcel to you in 10 minutes? Is it practical? Does it threaten the lives of people? Or is it completely exploitative? I think it is completely exploitative and totally unnecessary. Details when I'm back.
Quick breather.
ये है सीक्रेट रेसिपी MDH का जीरा सिप जल जीरा मसाला।
सिप सिप जीरा सिप MDH का जल जीरा सिप MDH का जल जीरा सिप।